Unlawful Activities Prevention Act, known more commonly as the UAPA. Syed Iftikhar Andrabi was arrested in 2020 for his alleged connections to a National Investigation Agency case involving narcoterrorism. Along with UAPA, he was also charged under the Narcotic Drugs and Psychotropic Substances Act. And after spending over 5 years in jail, the top court granted Andrabi bail. They said that authorities did not find any evidence directly connecting the accused with the crime, and hence bail could be granted. On the bench was Justice P.V. Nagaratna and Justice Ujjal Bhuyan, who, while granting bail, wrote this in their judgment. We have serious reservations on various aspects of the judgment in Gulfisha Fatima, including foreclosing the right of the two appellants to seek bail for a period of 1 year. The judgment in Gulfisha Fatima would have us believe that Najib is only a narrow and exceptional departure from Section 43D5, justified in extreme factual situations. It is this hollowing out of the import of the observations in Najib that we are concerned with. Najib refers to the 2021 Union of India versus K.A. Najib case, which essentially said that if someone is accused of a crime, even if it is something serious enough to warrant a UAPA charge, they can still get bail if the accused has been in custody for a prolonged period. And this judgment granted permission to override the statutory restrictions on bail under Section 43D5 of the UAPA. This part is important. Section 43D5 of UAPA makes it practically impossible to get bail if the court believes that the prosecutor has material which shows a prima facie case existing against the accused. In the Gulfisha Fatima judgment from this past January, the court granted bail to Fatima and 4 others who were charged under UAPA for their participation in the 2020 Delhi riots. Here, the court decided that their roles in the riots and the amount of time that they had already spent in jail warranted granting them bail. When we look at the data, we see that between 2019 and 2023, over 10,000 people were arrested under UAPA, but only 335 were convicted, with Jammu and Kashmir seeing the highest arrest numbers. Now, if we take a closer look at the data, we find that in 2024, 1,911 cases were pending investigation for over 3 years, and nearly 1,000 cases have been pending for between 1 to 3 years. And when we look at the period of cases pending trial, we see that in 2024, 1,683 cases have been pending trial for 1 to 3 years, 816 have been pending for 3 to 5 years, and 386 have been waiting for trial for 5 to 10 years. So the question that all of this brings up is, what is too long when it comes to awaiting trial for UAPA cases, and at what point does the severity of a UAPA charge and the restrictions that come with it impinge on the liberties promised in Article 21? To discuss this, I'm joined by Gautam Bhatia, a lawyer who specializes in constitutional law. I just want to start with, the fact that we've seen several cases related to granting bail for those who are charged with UAPA, and these have all had varied outcomes. And in Monday's Andrabi judgment, we saw that the Najib judgment was being referred to. So what's the legal precedent when it comes to UAPA cases getting bail, and is there any judgment that takes precedence over another?
I think, first of all, we have to note that many of the people who are in jail have not even been charged. So it's the charge sheet has been filed in many of those cases, but charges have not even been framed yet. So it's even worse than just being charged and being in jail for many, many years. But to answer your question, there is no consistency in the way that the courts have approached this issue. And so there is no one precedent that I can show you that definitively concludes the issue. I have referred to these two approaches of the courts as the eyes wide open and the eyes wide shut approaches. One, the former being one where the judges examine the claims of the state, because at the stage of bail under the UAPA, you can only look at the claims of the state. So they examine these claims with a degree of rigor and the eyes wide shut approach. They basically take the state's claims as gospel, and there is enough of a gap in both the statutory text and previous judgments for an individual judge in a particular case to basically pick which approach they want to take, depending on if they want to grant bail or not. So there is no precedent that will.
And these have all had varied outcomes. And in Monday's Andrabi judgment, we saw that the Najib judgment was being referred to. So, what's the legal precedent when it comes to UAPA cases getting bail? And is there any judgment that takes precedence over another?
I think, first of all, we have to note that many of the people who are in jail have not even been charged. It's the charge sheet has been filed in many of those cases, but charges have not even been framed yet. Means that you will get bail, nor can a judge hand down the ruling that says that 5 years in jail means you can't get bail, because it's not enough. These are fundamentally discretionary judicial issues that flow from the discretionary gap left in the text of the UAPA. And as far as the Delhi police goes, the classic case on the judicial approach to bail is a case called Vatali, which anyway really limits what the court can do. So to me, it's unclear what the Delhi police want beyond what they've already gotten in with the Vatali case, because that still governs the approach of the courts. And of course, again, like I said, individual judges then, based on their proclivities to either grant bail or not grant bail, can work within the interstices of these cases. But ultimately, it's going to always come down to that. So you can set up a 13-judge bench, and it's not going to be able to, lay down some rule that okay, like this is bail, this is not bail, because bail ultimately is discretionary. The real problem lies with the architecture of the UAPA that allows for a very, very lengthy pretrial incarceration.
Okay. So when you refer to the way that the UAPA is written, does that have to do with Section 43D5? Is that
Yeah, that is the bail section, yeah. And of course, also like the wording of terrorism, terrorist, offenses, all of that, which a few judges have tried to also, limit in the past. But it's both the definition of the offenses and the UAPA is very broad. And that's important because under the UAPA, if in the view of the judge there is a prima facie case that the offense was committed, then the judge is statutorily barred from granting bail. But the question of whether the prima facie offense was committed or not depends upon how you define the offense. So the High Court in the Devangna Kalita, Natasha Narwal and Asif Iqbal Tana judgment had basically said that you must interpret the word terrorism narrowly because it's a penal statute. It's basic logic. And so mere chakka jam, blocking of roads does not even fall within the UAPA scope, and therefore even if you take the police evidence as true, it's still not making out the offense. So you can see how the substantive definition of the offense will then inform the court's assessment of bail, except that the Supreme Court said that you can't take this case as precedent, which is completely outside the Supreme Court's jurisdiction to say, but anyway they said that, so that's where we are now.
Okay, I have one slightly simplistic question, which is my understanding of bail correct in that it can't be granted if there's some sort of threat that the person might flee or they might not show up for their trial? Is that
that's the classic test for bail in normal cases, so non-terrorism cases. So there, what you look at is the person a flight risk? Might the person intimidate witnesses and tamper with the evidence, and the gravity of the offense? And normally, if those are fears that can be overcome with certain bail conditions, you attach those conditions to bail, which would limit or constrain the person's movements and so on. Which again, its own hornet's nest, so we won't go into that. But if you think those conditions can't be overcome, if you think that those threats can't be overcome, then you don't grant bail. The UAPA has the additional requirement that if on considering the police report or the charge sheet, you as the judge think that there is a prima facie case against the accused under the UAPA, then you are legally barred from granting bail, which is of course a very low threshold. And the entire judicial struggle around the UAPA has been about what does prima facie case mean and what standard of evidence must you hold the state to at this stage of considering bail.
And at what point does that start infringing on Article 21? Because we have data that shows that there's hundreds, if not thousands, of cases that have been just waiting trial for over 3 years, 4 years, 5 years.
Well, I would say it starts infringing on the right after day one, because why should a person who's not been found guilty of a crime be in jail even for a single day? I think we in India have normalized incarceration to an extent where our threshold for when it's too much is 5 years or so. And you think of a human life, and 5 years would be around 7 to 8% of a human life spent in prison without trial, without anything being proved. And you think of all the consequences that will then occur when a person is released from jail after 5 years, or things they've missed, and the relationships that are destroyed, and the professional opportunities that are gone. If a constitution is serious about the right to life and liberty, then in my view it starts on day one. 1 day is too many, but it seems to be that the Supreme Court has arrived broadly as a ballpark figure of around 5 years, which doesn't always work because of the Omar Khalid and Sharjeel Imam are still in jail. But it seems to be that in general, it's around 5 years when they start to say, okay, this is now too much.
So I wonder what kind of caused the bench this time to say the statement and why they're now kind of reflecting. Maybe I don't want to.
No, these are two judges who are well known to be, broadly, I would say, on matters of personal liberty, liberal in their approach. That's the only reason. Yeah.
But will that have any effect going forward?
Well, that has to be seen in the future. The problem with the Indian Supreme Court is that the composition of benches is decided by the Chief Justice of India, and of course, the Chief Justice is well aware of the judicial philosophies of his fellow judges, and this is something I've been writing about for many years. And so ultimately, it really comes down to if whoever is Chief Justice at any given point are themselves, of a liberal bent of mind on personal liberty, or of a conservative bent of mind on personal liberty, and what we have seen in the past is that often this is then what informs the entire court's, approach, because then the assignment of benches will depend upon the Chief Justice. So I think this is like something you can't predict until you see how it plays out in successive tenures of Chief Justices, like going forward in the years to come. Because this has been going back and forth for a long time now. Like before Andrabi, there was Vernon. Before Vernon, there was like Najib. So this is a tug of war that has been going on for at least 7 or 8 years, where like a conservative bench will try and narrow down the scope of personal liberty, a liberal bench will expand it, and then it'll just go back and forth. That's what we've seen for many years now.
Gautam. Gautam, thank you so much for explaining this issue to us. Thank you so much for watching this video. If you enjoyed this video, please make sure to like, share, and subscribe to The Hindu's YouTube channel so that you don't miss the next one.